Be seated, please. I realized after I sent the instructions into you, I had not taken out the victim impact paragraph. I've now taken that out. Other than that, it's what I sent in previously. Any issue as to the jury instructions from the state? It's the same as what I sent in before, Mr. Evans. Other than I took out the victim impact statement.
Yes, sir. They're fine.
What's that?
It's fine.
All right. Defense?
No, Your Honor.
All right. So we're ready for jury. What I'm going to do is I'm going to instruct them down to the part where it says that, in just a few moments, so the last page, I'll stop there. Then we'll give you an opportunity to make any closing you desire to make. All right? Grab a jury, please.
Jury's in the courtroom.
All right, everybody be seated, please. All right, next thing I'm going to do is instruct on the law that applies to this part of the case. Members of the jury, you've heard all the evidence and argument of counsel. It's now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proved beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1, Henry Segura was previously convicted of another capital felony. A contemporaneous conviction for a capital felony may qualify as a prior conviction under this aggravating factor. The crime of first-degree murder is a capital felony. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. The aggravating circumstance applies where the dominant motive for the murder was to kill a witness. The existence of other motives for the killing does not preclude the application of this aggravating circumstance. 3, the first-degree murder was committed for financial gain. 4, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Brandy Peters, to Maya Peters, to Naya Peters, or Javante Segura. 5, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 6. Tamaya Peters, Tanaya Peters, or Javante Segura were persons less than 12 years of age. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. Excuse me. If, however, you unanimously find that one of the, or more of the aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find that the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose the sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: Henry Segura has no significant history of prior criminal activity, the existence of any other factors in Henry Segura's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proving aggravated factors and establish mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravated factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous, and your decision to impose the sentence of death must be unanimous. You'll be provided with a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. Deputy. All right, let's look at the verdict form. Unfortunately, it's a little complicated because we have the steps that you have to go through, and for each of those, you have to consider it as to each count, and there are 4 different counts, so it gets a little complicated, but I think once you get into see the pattern of it, it'll be fairly clear-cut. So the first thing you have to look at are the aggravating factors, which is in subsection A. The state has alleged 6 aggravating factors. You need to make a decision as to each count what aggravating factors have been proven as to that particular count. The first one would be as to Brandy Peters in count 1. The court has eliminated 2 of the 6. So you have 4 aggravating factors that you're to decide whether have been proven beyond a reasonable doubt or not. You would check each one that you find has been proven as to count 1, dealing with Brandy Peters. Then you would do the same as to count 2. As to the children in counts 2, 3, and 4, they're the same. The court has eliminated one of the aggravating factors as to them, so there are 5 potential aggravating factors that you're to determine. So as to each of the aggravating factors, as to each of the counts, you would decide whether the state has proven them beyond a reasonable doubt or not, and you would check that. If you go to page 5, the bold language at about 2/3 of the way down that page is very important, so let's read through that. If you answer yes to at least one of the aggravating factors listed in a count, so it's done by each of the 4 counts, please proceed to section B as to that count. If you answered no to every aggravating factor listed in a count, do not proceed to section B in that count. Henry Segura is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole as to that count. So you have to consider it as to each of the counts. If there are no aggravating factors proven beyond a reasonable doubt as to a particular count, you're done. You don't have to do anything further as to that count. If you find that at least one aggravating factor has been proven as to the count, then you would move on to B, which is sufficiency of the aggravating factors. And again, it's broken out into each of the 4 counts as reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in section A. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. So as to each of those that you found an aggravating factor, you need to answer that question, yes or no. Then let's go to page 6. The bold language at the bottom of page 6, I think, is worth reading through. If you answer yes to section B in a count, please proceed to section C in that count. If you answer no to section B in a count, do not proceed to section C in that count. Henry Segura will be sentenced to life in prison without the possibility of parole as to that count. So any of them where you say no, your job is done. If you say yes, then you need to go to C. C relates to mitigating circumstances. Again, it's broken out by counts. It says one or more individual jurors find that one or more of mitigating circumstances were established by the greater weight of the evidence, and you would check yes or no. Now, note this is not necessarily a unanimous decision. This is the first time where it does not have to be unanimous. It says one or more individual jurors, so any juror could determine that this is yes. It says, please, the bold at the bottom of the page, please proceed to section D, regardless of your findings in section C. Then in D, the question is, we, the jury, unanimously find that aggravating factors that were proven beyond a reasonable doubt back in section A outweigh the mitigating circumstances established, which are found in section C. Would be yes or no. Again, it's broken out by counts. You would answer yes or no as to any where you're still proceeding. In other words, there are some where you may have already concluded from the prior subsection. If you answer yes to now I'm on the top of page 9, look at the bold language. If you answer yes to section D in a count, please proceed to section E in that count. If you answer no to section D in a count, do not proceed. Henry Segura will be sentenced to life in prison without the possibility of parole in that count. Under E, the question again is broken out by count. Having unanimously found that at least one aggravated factor has been established beyond a reasonable doubt, back in Section A, that the aggravating factors are sufficient to warrant a sentence of death as to Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Henry Segura should be sentenced to death, yes or no. You would do that as to any counts that you're continuing to proceed with from early. And now, at the bottom of page 10, the bold language, if your vote to impose death is less than unanimous in a count, the trial court will impose a sentence of life imprisonment without the possibility of parole in that count. It would then be dated and signed by the foreperson. So I know that's a little complicated, but it's kind of, I think if you follow it along, I think it flows through it. We've tried to make it self-explanatory. Now back on the jury instructions, page 5, right after read verdict form, the fact that a jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. I've previously instructed you on weighing the evidence and rules for deliberation. You should consider the instructions I gave you during the initial stage in making your determination. A copy of those instructions will be provided to you for your consideration. Now, I'll come back to the last page after the attorneys have been given an opportunity to make give a closing argument,